Well, hello, and I wanted to thank everybody for attending this webinar on Americans with Disabilities Act and Public Libraries. Just a few things right off the bat. This issue with ADA has become something that's more frequently asked of us in our capacity as attorney for public libraries. So I'm aware of some of the issues that libraries have been facing, and we've tried to gear this particular presentation towards kind of the most common issues that I see. One of the things that's really important about the ADA is that it's a very fact-specific analysis when you're determining what is the appropriate action for a public library with respect to patrons in the ADA. So this session is going to be kind of a broad overview of what the law is and what the requirements are. But with respect to the specific decisions that you make on a particular ADA issue, whether to make a reasonable accommodation, what that accommodation should be, how to handle a patron issue, my recommendation would be to consult with your particular attorney on that issue. And the point of this seminar is to give you the big picture so you can issue spot issues and things that may come up with respect to patrons. I also want to make clear that this presentation is covering patron issues, libraries, how libraries deal with patrons and how the ADA affects that. It's not a session that is geared towards your responsibilities with respect to your own employees and reasonable accommodations. So with that, I want to get started on what the law is. So these are the big issues that we're going to cover today. Well, first of all, we're going to discuss what the ADA is, what your requirements are, and what's a disability under the ADA. And then after we've done all of that, what we're going to do is talk about what reasonable accommodations that libraries are making with regard to their services for disabled patrons. Next, we're going to discuss what the library must do as far as the structural encumbrances in a facility. So that will cover, especially with libraries that have old buildings, you know, old historic buildings, what are you required to do as far as accommodating people with disabilities when the structure may not be up to ADA compliance. The next topic we're going to discuss is service animals or comfort animals, and this is one of those that has become a huge issue for libraries. I think not only for libraries but a lot of other entities. And what is a service animal and what's a comfort animal and what laws apply to each one of them. And then I want to just talk briefly about the Library Privacy Act with respect to disabled adults especially. So are libraries covered by the ADA? And the answer to that is yes. Title II of the ADA applies to public libraries. And really what that is that all activities, services, and programs are covered by the ADA, including meetings and library programs. And there's no tie to federal funding. So there's some federal laws that only apply if you take state aid. SIP, Children's Internet Protection Act, for example, is one where the requirements only apply if you take certain E-rate or LSTA grants. Here, there is no tie to federal funding. So if you get 100% of your funding from state and local government sources, which most libraries do, except for grants and all of that, you still must comply with the ADA. So the next two slides give you a general overview of what the protections of the ADA are. What the ADA does is require places of public accommodation, which is Title II and what a library is, to be accessible to and usable by people with disabilities. The library may not exclude people based on a disability except if there's a direct threat to health and safety of others. And I give you one example that may be a threat. For example, if a person with tuberculosis, which is a very contagious and serious disease, wants to teach a children's program, for example, that may be a situation where there's a threat to public health and safety. You also must have reasonable modifications to your policies, practices, and procedures so that people with disabilities may participate. And I want to pause here because these next two slides cover kind of the general protections of the ADA, and we have a number of more in-depth discussions on some of these bullet points. So I want to get that out there. They also eliminate unnecessary eligibility standards or rules afforded to people with disabilities unless a fundamental alteration in the nature of the program would result. When necessary, a library must furnish auxiliary aids to ensure effective communication unless an undue burden or fundamental alteration would result. You have to remove architectural or structural communication boundaries in existing facilities and provide alternative means of delivering services when removal of boundaries is not readily achievable. If you are doing a new building or undertaking alterations, you must alter the existing facility to be ABA compliant. So those are a broad overview of what the requirements are for the ADA. So what is a disability under the ADA? A disability is defined as a physical or mental impairment that substantially limits one or more major life activities. It does not apply to an impairment that's not substantial. And the federal government gives us examples such as a mild allergy to pollen. You know, for example, if you had a program that was outside and one of the patrons wanted you to move it inside because of a mild allergy, that would not be a disability that you're required to address under the ADA. It applies to people who have a record of impairment, such as visible scars, and it applies also to the perception of impairment. And we'll get into what that means a little bit later. So this is what the disability is, physical or mental impairment that substantially limits one or more of major life activities. A physical or mental impairment includes any physiological disorder or condition affecting the neurological or muscular skeletal system of the body. The phrase major life activities means functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, or learning. This would apply even if it only temporarily impairs a major life activity. For example, if someone was severely burned in a fire, that person may be expected to heal long term, but they may need assistance until they're healed. And so during that time, they are considered to have a disability, even if it's only a temporary disability. You have to also be careful for people who are regarded as disabled, because you cannot also discriminate on people based on what you perceive to be a disability. For example, they give as a child is barred from a library program because of diabetes that's controlled by medication. The child may be perfectly able to attend that program, but if there's a perception that that person has a disability that prevents them from doing that, even though that's not an actual disability for the purpose of the program, then you may have a problem. Okay, so be careful about, you know, people who are actually disabled and then people who you perceive to be disabled. One of the components of the ADA is to require integrated accessibility. And what this means is that you don't have, the whole goal of the ADA is that people with disabilities will be able to participate equally in services and programs as people who are not disabled. Okay, so it's not going to be sufficient for the library to separate people with disabilities if in fact they can reasonably participate in library programs. And this is an example where you may have a program that's specifically geared towards people with disabilities. For example, you may have a children's program that has special features that are geared towards kids who are hearing impaired, for example, and you may encourage those with those disabilities to attend that to attend that programming. So if you have a sing-along that's geared towards kids with hearing impaired, would be fantastic. That's a fantastic program, but you cannot then prevent children from attending a regular sing-along that's not geared towards those with impairments merely because they have a disability and merely because there's a separate program that would be specifically geared towards those with a disability. So that's one thing to keep in mind, is that you may not, you have to allow equal access to the same program if at all possible. Integration so that those with disabilities don't feel separated and apart from other individuals with respect to library programming and library services. be careful, we talk about this with other areas of the law. You have to really be careful about unintentional discrimination. For example, if you require a driver's license to attend a library program, and you're doing that as to make sure that you have properly identified those that are participating, you may unintentionally discriminate against the visually impaired, because the visually impaired person may not have a driver's license but may be perfectly able to attend a library program. So you don't want to put a barrier up that's not related to the program. Now, if you had a library program that was, beginner driver's ed, and that's part of your library programming, and the person needed a driver's license as an essential element to participate in the program, that's something that you can consider, and that's something that can be a requirement. But if you require a driver's license to allow someone to attend a, workshop at the library or a book study at the library, then this is probably not something that's going to pass muster under the ADA. It has to be based on actual risks and not speculation. And that's one of the hardest parts about, I think, the ADA and the ADA compliance, is that you really have to put yourself in a position where you are not making decisions based on what the perception is of what the person can and can't do, but what they actually can and can't do. So again, you've got to be careful about the perception as well as the actual disability. So a public entity shall make reasonable modifications to policies, practices, or procedures when the modifications are necessary to avoid discrimination on a disability, okay, unless the public entity can demonstrate that making the modification would fundamentally alter the nature of the service, program, or activity. Here is a situation, and this is the most common, I think, part of library programming that the library is going to have to deal with, is what is a reasonable modification? And what happens if the modification that the library thinks is reasonable is different from the modification requested by the individual with the disability? And what happens if that modification would fundamentally alter the nature of the service, program, or activity? And this is the area of law that I think that is really hard to apply. And so we look at the specific facts of each situation and make a reasonable determination based on those facts and circumstances. So what I'm going to give you is the basic overall legal principles, but the reasonableness inquiry, as you can see by this second bullet point, is very fact specific. So especially when dealing with this type of issue, it's very important that the public entity talk to their legal counsel about this to avoid any potential ADA violations. Okay, so a public entity does not have to provide the requested accommodation if they can demonstrate a fundamental alteration or undue burden in the program. And the ADA defines an undue hardship as an action requiring significant difficulties or expense when considered in the light of a number of factors, one being the type of service or product offered. So what does this mean to a public library? One of the things is that, if you are hearing impaired and you have several options if you want to assist those that have hearing impairments. For example, you could take notes and show the notes to the person with being hearing impaired. You could provide worksheets or advanced copies of materials for the program in advance. You could provide different aids to people with different disabilities. We have to make sure that there would be no fundamental alteration of the program. And there's not a lot of law on this with respect to public libraries. That's the other challenge that libraries face. We don't have a whole history of case law that we can look to and say, oh, well, in this case, the court found that this was reasonable. In this other case, they found that it wasn't. So we're going to follow what the court decided was reasonable. We have to base it on case law applying to other types of municipal organizations, and this is one of the cases that I want to talk about to give you some of the idea of what the courts say as far as how far the plaintiff has to go, or how the city in this case has to go to accommodate the plaintiff. And in this Jones versus City of Monroe, the plaintiff had multiple sclerosis, and alleged that the municipal parking program violated the ADA. And what happened was she had a place of work that was very close to one of the municipal parking structures. And in that parking structure, though, that was closest to her work, they had handicap and disabled parking, but it was only 1 hour maximum. She could park several blocks away and have unlimited hours of parking for free, but it wasn't as close to her place of business as she wanted. Well, the court concluded that what she had asked for was she requested that the city reserve a free parking spot for her in this parking spot and stop ticketing her when she parked in the 1 hour parking spot for the whole day. And the court concluded that the assignment of a particular parking location or immunity from prosecution is not a reasonable accommodation under the ADA. The reasonable accommodation would be to allow her to park several blocks away in a space that was open all day, and that was not a reasonable accommodation. Okay. In another example, this one involved a jail, and a public entity does not have to provide, again, the specific accommodations requested as long as the accommodations that are provided are reasonable. Here, the plaintiff in this case was blind and stated that the jail violated the ADA by refusing his request for auxiliary aids. So what happened was he wanted to avail himself of the legal resources at the jail, and had been working on briefs with someone in the jail program, and the jail program was reading the briefs back to him. Well, his argument was he should be able to independently review his briefs and legal documents without relying on a third person to repeat his language back to him. He wanted to personally be able to go over that material. And he requested these auxiliary aids that included braille or audio copies of the documents and a digital reader. That's not what the jail provided him. The jail had provided him with the assistance of this legal writer program, which was essentially people reading the documents to them. And the court stated that the plaintiff did not receive the technical relief he sought, but that the plaintiff received through the assistance that he received through the legal writing program was sufficient to fulfill the reasonable accommodation component of the statute. So how this plays with libraries is that you may have a situation where you have a choice. You have a choice of reasonable accommodations. And the choice may be between the accommodation requested by the individual or the accommodation that you believe is reasonable. And I'll give you an example. Let's just say that that you are having a children's program, and one of the parents wants to attend the children's program. There may be a circumstance where the parent has requested someone come in and do sign language, a signer, where the library may feel that the best accommodation would be to give the patron sheets of the music so that she could follow along with the sing-along with the child. Now, what's going to be the reasonable accommodation is going to come down to what the program is, what the costs are of these different aids. Will it change the fundamental nature of the program? Those types of things are all going to factor into the decision of what is reasonable. Examples of things that are reasonable, where libraries may make reasonable accommodations is that if you have a meeting, let's just say you have a library that's old, it's pre-ADA, doesn't have an elevator to certain parts of it, it's not accessible. If you have a first floor that's ADA, accessible to all people with disabilities, moving a conference room or moving a meeting from the upper floors to the lower floor would likely be a reasonable accommodation that you could make instead of having to build, or put in an elevator to make sure that the individuals could reach the meeting. Again, I give the example of providing music sheets to people who attend to sing along. Retrieving books from the stacks or other confined areas that will not allow a wheelchair to pass. And I've been in a number of old libraries that are absolutely gorgeous. And I go into parts of the library, and one of the questions I always ask the staff there is, so what do you do if someone who has a disability wants to come in here because the stacks are narrow, there's no way a wheelchair could pass between the stacks? And typically it's, that they have a staff on hand that will go up and retrieve any book for that person for them, and I think that would be considered a reasonable accommodation. Allowing a person with diabetes to bring food into the library if it is otherwise prohibited. These are the types of accommodations that you may be called upon to determine. Now, it's what really adds to the issue is, and most of the calls that I get are, whether there's a question about whether the person has a disability to begin with, and that's always a really tough question that the libraries have to grapple with. And then, assuming that they do have a disability, what's the reasonable accommodation for that person with a disability? There's what the federal government's intent is, and you can see this in all the material that the federal government puts out about ADA compliance, is what they really stress is the library working with that particular individual and figuring out mutually what would be a reasonable way of accommodating their disability. And that's the whole goal, is to make sure that they receive as similar, same services as any other individual, and that if that is not possible, that they are reasonably accommodated to make it as close as possible, so that there's no barriers to a person, unreasonable barriers to a person receiving the program or service from the library. So if you have, and many of you may have been through these issues before and may have kind of grappled with them, and every issue that I'm involved with, it really comes down to a lot of decision making on the part of the library, a lot of analysis of the facts on hand. So these aren't always easy answers. They may be more simple in some cases where the person with a disability requests an accommodation that's very easy for the library to manage, and so not only do they get the accommodation they're requesting, but it's very reasonable for the library to do. Those hopefully are the majority of the cases. It's where there's a difference of opinion on what the accommodation should be, or a feeling that the person may be asking too much of the public entity. That's where I think certainly you should get legal counsel involved to make sure that there's no issues with respect to the ADA. I put this in here just to talk about library board meetings, because what we want to make sure is that the library board meeting is an open meeting. There's a requirement that any person be able to attend. Certainly it should not be held in a location that's not accessible for people who have a disability. So if you have a stack and someone's looking for a book and you can send a staff member up to retrieve the book, I think that's a reasonable accommodation. But to have a library board meeting in a place where it's not accessible to those with disabilities, there's no real substitute from being able to participate in that meeting, because the Open Meetings Act requires that anybody who attends the meeting have the right to speak at that meeting. So I think, even listening to a board meeting later, it will deny that person the ability to present their opinion in public comment before the public body. Public notices, all your public hearing notices, your regular meeting notice, all special meeting notice should include a statement that the library will provide auxiliary aids if requested within a reasonable time. Some libraries put, within 3 days or 2 days. And the notice should include contact information for the library director or other people responsible for the accommodation. It's a good idea now, if you haven't done it, is to find out how difficult it would be to get, for example, a signer to come to a library board meeting. In your particular community, could you do this on a day's notice? Would you need several days' notice to do this? Because this is what's going to factor into what is a reasonable time for them to ask for the accommodation. So again, that's a little bit of homework that you might think about ahead of time, in library programs too. If you've got a program planned and it's the next day and someone comes to you and says, I need someone to sign for this, and you know that there's no signer that's, available, on a day's notice, this is something that you need to discuss with the person at the time and figure out what's reasonable under those circumstances. So as long as the public library demonstrates that the accommodation it provides is reasonable, I think the library will be in compliance. One thing I might want to point out that the library may not charge the disabled individual for aids or services. So if it costs you $800 to have a signer at a library program, you cannot provide a $800 invoice to the person as they're leaving the program. That's one of the services, or that's one of the costs of doing business under the ADA for the public library. It is, incidentally, I think one of the factors to consider on whether, you know, it's reasonable or whether it will fundamentally alter the nature of the program. So, you know, different libraries may have the ability to absorb that in their budget a little differently than other libraries. But again, if you're going to deny a reasonable accommodation based on the cost, I would get legal counsel on that to make sure that there's no issue with that. So what about the library building? The library is not required, and this is like any other public entity, to make structural changes to existing facilities if there are other effective methods available to comply with the statute. With that said, there's no per se grandfathering of buildings. So I think there's a perception that if you have an old building that predates the ADA, you don't have to make any structural changes. And that is typically the case if, in fact, you can make accommodations to, you know, allow that person to participate in the services and activities of the library. And the classic example of that is the one we've been talking about, which is the stacks that are not accessible to wheelchairs and other you know, motorized devices. There's no requirement that you would have to build an elevator, or that you would have to, you know, widen the aisles of that part of the building, if in fact there's alternative ways to allow a person to get into the library. So keep that in mind. If you have an older building that's not ADA compliant, you are not necessarily 100% grandfathered from any requirements of the ADA. There may be some discussions you have to have with your board on that. Existing buildings that are renovated after the enactment of the ADA may be accessible to individuals with disabilities, and renovated. So trying to figure out what that really means. The routine maintenance would not be, I don't think, would trigger this renovation provision of the ADA. But certainly if you're going to make several structural changes to the library, add, you know, a wing, add a second floor, those types of things would likely trigger the renovation. So here again, this is maybe something, if you're in the building process, if you're in the renovation process, you might need to get an opinion on to what extent that renovation would trigger a overall view of what should be, you know, compliant with your building. For example, if you don't have a ramp that meets the requirements of the ADA, you have some sort of ramp and you're renovating the building, you may be required to put a ramp in that meets the ADA. Again, this is going to be one of those things that a lot of libraries are doing anyway. They want to be ADA compliant, but if you are doing a renovation and there's a question at all about whether the renovation would trigger the overall, you know, requirements of the ADA, I think that's something that needs to be looked into. Certainly new facilities are required to be constructed to be ADA compliant, and the public entity has the burden of proving compliance. So again, the issue with the library building is a little bit different than the issue with the programming, because they're obviously not going to require you to make structural changes to a building unless there's no other alternative method for providing the library service. With respect to existing facilities, public entities are not necessarily required to make accommodation. Physical changes to a building are required only when there's no feasible way to make the change of make the program accessible, and you're also not required to change an existing building that would threaten or destroy the historical significance of the historic property or result in a fundamental alteration of the nature service program or activity or an undue financial and administrative burden. So I want you to look at this through kind of the lawyer lens here. You can see where there's a lot of, this isn't very objective, it's pretty subjective. If you can see this, that result in a fundamental operation. What is a fundamental operation, okay? What would be undue financial or administrative burdens? These are all going to be things where the library is going to have to take a look at what it's doing. You know, for one library to put in a ramp that costs, you know, $20,000, that might have a different financial burden from another library that has a larger budget. So I don't think all libraries are going to be treated equally, and you're going to have to look at it with respect to your particular circumstances. And I've already given you the example about the stacks, about the elevator. I know I've been in a lot of old buildings that have a lot of narrow elevators, a lot of narrow stacks, and typically there's ways to accommodate that. If there is not, that's when you need to talk to your architect, and we need to get some consultation on whether the ADA would apply. So again, the public libraries have to ensure buildings constructed or renovated after the ADA are accessible to disabled individuals. Existing facilities may not necessarily be required to make changes unless there's triggers that result in that we've already discussed. So here's the big issue, I think, right now with a lot of libraries and a lot of public entities, and this is the service animals, okay? And one thing to really keep in mind is that there's a specific definition of a service animal. And under the federal ADA, there's a federal law, the ADA, and there's also Michigan statutes on service animals. And so they interplay a little bit, but they're basically complementary, and they're not inconsistent. So to comply with one is to comply with the other. So we want to make sure you're complying with all elements of this. But a service animal is defined under the federal law, and it happens to be the same to some extent under Michigan law, but as any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability, okay? There's a case I'm going to cite here, but I want to point out that after 2011, it only applies to dogs, and actually certain miniature horses can be service animals. So a cat is no longer a service animal, a monkey is no longer a service animal, a turtle is no longer a service animal, a bearded dragon is no longer a service animal, a dog is a service animal, and certain miniature horses. I actually don't know enough about miniature horses to know exactly why that exemption was made, but anyway, dogs and certain miniature horses. So that may be a change that you're not aware of, because, and we're going to get into this a little bit later, there's a difference between a legal service animal and what we refer to as a comfort pet. And the cats and the lizards and the rats and all of these animals are not service animals. They may be comfort animals, but they're not service animals as defined under the ADA. So the task performed by a service animal also must be directly related to the individual's disability. So generally, public accommodations shall modify policies, practices, or procedures to permit their use of service animals by individuals with a disability. So every library policy, patron behavior policy that we draft, we recommend that the library include a provision that excludes animals unless they're service animals. And then we often, on a slightly different tangent, but we often, you know, also exclude animals that are permitted in the library as part of a specific library program. But really, check your patron behavior policy to make sure that service animals are exempted from prohibition in a library. You want to make sure the face of your policies, we're going to talk about practice too, but we want to make sure that facially that your policies are compliant with the ADA. So how do you deal with this in practice? So you may not ask an individual whether they're disabled, okay? And I want to talk a little bit about that in a minute, but it's sometimes hard to recognize whether an animal is a service animal. So again, you have to make accommodations for service animals. You may ask an individual to remove an animal, though, if the animal is out of control and the animal's handler does not take effective action or control, or the animal is not housebroken. So interestingly enough, I think these are also two big clues that this animal is not a true service animal, because true service animals are very well trained, and they're very attentive to their master in order to make sure that their disability is taken care of. So if someone comes in and complains that their service animal, that they need a service animal, the service animal is out of control, it's barking, it's doing all these things, I think that's a good indication to the library that that service animal may not be a real service animal. Also, with respect to service animals, a public entity may consider whether the animal poses a direct threat, which is a significant risk to the health safety of others that cannot be eliminated by modifications, practices, or procedures, or by the provision of auxiliary aids or services. If you have what appears to be a dog that is out of control, that is barking, that appears that it may be violent, this is one of those things that you're going to have to evaluate as to whether you think that that animal poses a direct threat to the safety of others. This may not come up in the libraries as much as it does in other, other areas. For example, can you allow your a dog in an operating room? Can you allow a dog in a swimming pool? Can you allow a dog in a, public entity's kitchen? Those are more of the issues where they're going to be an analysis of a direct threat. I don't think those are going to apply to libraries as much as if the dog really is a direct threat because you think it's going to cause physical harm to staff or other patrons. So the public entity is not allowed to inquire to the extent or nature of an individual's disability, but may undertake 2 inquiries to decide if an animal is a service animal. You may ask whether the animal is required because of a disability and what work or task the animal has been trained to perform. Okay? This is the trickiest part, because a lot of times you may have to take the person's word for it. Okay? The dog may come in and it may not look like a typical service dog. I mean, stereotypically you see service dogs that are, helping people, who have visual problems. They're typically larger dogs. They're typically, labs or German Shepherds or Golden Retrievers, those types of dogs. So you may have someone that comes in with a lap dog and says that this dog is, trained to perform, to help them walk. Well, I think at some point, and this is again something you should go over with your own particular lawyer, but more often than not, you're going to have to take the person's word at face value, because you can't ask for proof or identification or anything like that. Okay. It says, and also if the entity may not make these inquiries if it's obvious that the animal is a service animal and should not require documentation to confirm that the animal is trained or licensed as a service animal. I find this one a little bit interesting, because I'm not so sure it's always obvious that an animal is a service animal. For example, I was out at an event outside at a park and encountered a German Shepherd that had a vest on that said "do not pet." So my immediate thought was that this is a service animal because they have the vest, it says "do not pet." Typically service animals say "I'm working, don't pet me," those kinds of things. So I asked the individual, I said, "Oh, what is the dog, what is the dog trained to do?" And she said that the dog is trained to do nothing. As a matter of fact, it's not very well trained, and we were worried that he's going to bite somebody. So the "do not pet" is not because the animal was a service animal. The "do not pet" was because the animal is potentially dangerous. So if someone walks into the library with a German Shepherd that has a vest on that says "do not pet," I think if you looked at these in 9 out of 10 circumstances, you would think that that would be a service animal. In this case, it wasn't. So you have to be kind of careful about those type of circumstances. Here's some Michigan-specific issues with respect to service animals. A person should not falsely represent that he or she is in possession of a service animal in training, or in any public place. It's actually a crime to tell people that you have a service animal when in fact you don't have a service animal. Again, a service animal in Michigan is the same term as defined, and that's the 828 CFR site is the same site that's in the federal one for the dog. And then the miniature horse that's been trained to perform tasks to the benefit of the person with a disability. Again, it's a misdemeanor if they violate this. Again, Michigan law is consistent, but in Michigan, the service animal has been under the control of the handler, have a harness leash or other tether, unless the handler is able, is not able to use that tether. So, again, I think most legitimate dogs that are working dogs are meeting these requirements, and I think any time that there's an animal in your library that doesn't appear to meet these requirements, I think that's when you can make some of the inquiries about whether that's trained for a disability or not. Again, you have to be careful too, because with certain types of dogs, there's certain types of dogs I mentioned that are more stereotypic than others, but there are a number of dogs that are being trained now to do certain other tasks that may not be the typical service animal. For example, there's dogs that are trained to sniff out or smell glucose levels in people with diabetes, and so just be careful if the person that walks in looks to have, like, visibly you can tell that that person has a visual impairment or some sort of disability. That's when I think that the inquiry should stop. But there may be people that come in that have disabilities that are sort of unseen disabilities that require service animals that will be under the protection of the ADA. Again, a public entity cannot charge an individual with a disability or make them comply with other requirements that are not typically applicable to other patrons. However, if a public accommodation normally charges people for the damage caused, then the public accommodation may charge an animal with a disability or damage caused by his or her service animal. So, for example, you can imagine a case where if someone's using the meeting room and is charged carpet cleaning for spills and other types of incidents that happen on the carpet, it may be reasonable to charge a person with a disability if their service animal, has an accident on the carpet as well. Those are one of the things, again, that if you're going to do something that's, maybe you're questioning whether it's compliant or questioning whether it would be lawful, I think that's when the inquiry needs to happen with your lawyer. And again, some state, you have to be careful about state and local health codes as well, but I do not think that that's going to be as much of a problem for libraries as for other types of animals. So, do comfort animals qualify as service animals? Courts have said that an animal must be specifically trained to perform tasks directly related to the disability, contrasted with animals that have received only general training, provide only emotional support, or otherwise perform tasks not directly related to the disability. So basically, comfort animals are not going to be considered service animals under federal or state law. So in this case, there was a puppy that was not considered to be a service animal because it only received obedience training and was used by the plaintiff for emotional support and comfort, which is the type of aid excluded as work or tasks under the ADA. So in this case, a monkey was not considered a service animal as the task it performed was not required for the day-to-day activities of the plaintiff. The monkey, again, merely provided comfort and support to the plaintiff and did not qualify as a service animal under the ADA. And I made a note because this was a 2009 case. After 2011, the fact that it's a monkey should let you know automatically it's not a service animal because monkeys can no longer be service animals under the law. So comfort animals would not classify as service animals under the ADA. To qualify as a service animal, they must be trained to carry out tasks related to the disability, but you can make very limited inquiries. And because of this, I'm just going to tell you that based on my experience, it's going to be very difficult if someone brings a dog into the library. It's going to be very difficult to determine the line between a comfort animal and a service animal. And because of that, a lot of public places have to tolerate comfort animals in the library because they would rather tolerate it than take the risk that they're going to be in violation of the ADA. Again, if you've got a person that's a typical patron, the patron always comes in with the dog, it's becoming a problem with the dog, I think that's the time where you may want to start investigating whether that dog qualifies as a service animal under the ADA. I also want to talk about wheelchairs, mobility aids, and other power-driven mobility devices. This is kind of an interesting issue with libraries because we're getting some more inquiries about people who want to use like power wheelchairs, scooters, power manual mobility aids in the library. So the rule is that covered entities must allow people with disabilities to use other types of power-driven mobility devices in their facility, unless a particular device cannot be accommodated because of legitimate safety concerns, okay? So what this means is that if, and these are the types of factors on, the rule sets out 5 specific factors to consider and depending whether or not a particular device can be accommodated. First of all, wheelchairs, what type of wheelchair, what is the choice of the device by the patron, what other powered mobility devices may be accommodated, and these are going to be some of the assessment factors that you're going to have to consider in whether a particular device may be accommodated. Most people are familiar with manual and power wheelchairs and electric scooters, and we're giving you the definition of a wheelchair. But in recent years, some people with mobility disabilities bring less traditional methods such as golf carts or segways. So in addition to wheelchairs and scooters, now they call them the other power-driven mobility devices. As any mobility device powered by batteries, fuel, or engines that is to be used by individuals with mobility disabilities for the purpose of locomotion, including golf carts, electronic personal assistance, and such as segways, okay? But not a wheelchair, because these are going to be things that are powered by sources other than the individual's own muscles or body power. When these other power-driven mobility devices are used, different rules apply to these under the ADA than when a person who may not have a disability wants to come in to the library. So again, the people with disabilities have a right to choose whatever mobility device best suits their needs. So if a person comes in with a manual wheelchair, that's their device of choice, they may choose that device because it better enables them to get around. Similarly, someone who's able to stand may want a Segway rather than a manual wheelchair because of the health benefits gained by standing. You have to allow the type of device generally, unless it's going to be specifically prohibited or specifically not conducive to the environment or something that can't be accommodated. For example, a gas or fuel-driven golf cart or battery-operated golf cart probably not able to be accommodated in the public library. Even if it's under a battery, it's going to be big. It's not going to be able to move around. You don't want gas fumes in the inside of a library. So those are the types of devices that would be acceptable likely for a library to allow or to say this is not appropriate for the library setting. So under the new rules, covered entities must allow people with disabilities who use wheelchairs and manually powered devices into all areas of the facility where members are allowed to go. So if you have a situation where someone wants to bring a Segway into the library, first of all, if they have to be a person with a disability. You can't just allow anyone to bring a Segway into the library. But if a person with a disability brings a Segway into the library, and the library can accommodate it, for example, they've got, wider, areas, you have to allow it in the same way you would allow a wheelchair or a scooter, okay? And the safety requirements have to be based on actual risks, not on speculations, okay? People might say, oh, Segways are fast and they're going to run over children and all of that. I think as long as you have reasonable rules in place for the use of those are going to be kind of speculation or stereotypes rather than actual risks. So in deciding whether a particular device may be accommodated in a particular facility, these are the factors you have to consider: the size, weight, type, and dimensions and the speed of the device, the facility's volume of pedestrian traffic, the facility's design and operational characteristics, whether legitimate safety requirements can be established to permit the safe operation of the vehicle in the specific facility, and whether the use of the vehicle creates a substantial risk or harm to the immediate environmental or natural or cultural resources. So again, you're going to have to look what's reasonable under these factors. For libraries, most of the libraries will be in a situation where segways, scooters, those types of things will likely be permitted just as wheelchairs would be in those types of accessible areas. Now, we've talked before about stacks and other areas that may not be accessible. Again, the same rules would apply as long as staff is able to go to those sections to allow someone with a, motor-driven device access to that, then likely there's going to be no problem under the ADA. So in deciding whether a type of mobile device may be accommodated, they can consider all the assessment factors and where appropriate should develop and publicize rules for people's disabilities. And I think these are 4 rules that libraries can put in their policies to accommodate it. One is requiring the user to operate the device at the speed of pedestrian traffic. This is something where you have to make sure that you don't have someone who's got a Segway or a scooter and is driving through the main part of the library, kind of at a high rate of speed and is at risk to other patrons. Identifying specific location terms and circumstances where the devices cannot be accommodated. I mean, I think it's reasonable to say that you may have an elevator that is not wide enough to accommodate a particular type of scooter. And I think those types of locations, terms, and circumstances should be addressed in a policy. Also, setting out instructions for going through security screening machines if the device contains technology that could be harmed by the machine. I don't know how many of you have security screening or machines or other devices that could be harmed by that machine, but then policies will have to be put in place to address that. Specifying whether or not storage is available for the device when it's not being used. I mean, can you just park your Segway or your motor, your little scooter anywhere in the library? Is there specific parking spots for them? I mean, those are things I think are reasonable to address. But again, this might be one of those things where you have 1 or 2 patrons that are using these types of devices, and you're going to have to figure out a way to accommodate those types of uses. An entity that determines it can accommodate 1 or more types of uses in its facilities is allowed to ask the person using the device to provide credible assurance that the device is used because of the disability. If the person presents a disability parking sticker or state issue proof of disability, that must be accepted as credible assurance. If the person does not have the documentation but states verbally that it's being used because of a mobility disability, that must also be accepted as a credible assurance, unless the person is observed doing something that contradicts that assurance. If the person comes in, says they have a disability, needs to use a Segway, and then you see them, running a marathon the next day, I mean, this is one of those things where you have to have some pretty concrete evidence to assure that they're doing something in contradiction of the statement that they need the mobility device to help them with their mobility disability. So again, ongoing staff training is essential. I think this is not only true with the devices, but also with respect to any other type of ADA issue that staff should be instructed about what devices, the rules for obtaining credible assurances for the devices, and in fact in the rules for determining whether a person has a disability, if the service animal is a proper service animal, what you can and can't say. I think typically my recommendation on things like this is that to the extent that possible, the library director or those that are or his or her designee or people that are very senior staff should make the inquiries and should be the ones that are making judgment calls on this, and not leave it up to your circulation staff or newer employees to make kind of these difficult decisions. I do want to bring up one issue with the Library Privacy Act before we go, and this only comes up because the Library Privacy Act prevents you from identifying a patron's name, address, or telephone number, or that identifies a person as having requested or obtained specific material from a library. And this comes up with an issue that it's a frequent issue with respect to, can parents get information about the library material about their minor children? And in that case, they can, if they have written consent of the person liable for payment or return of the materials. And so what that typically means in the general context with kids is that you know, if the parent signs and agrees in writing that they are liable for payment and return of the materials, then the library is permitted to release the information about materials to the parent. The tougher issue, and the issue that I think is not addressed in a lot of policies, is what do you do in certain cases with people who are, you know, children with disabilities or also adults with disabilities. So you may have a disabled adult that uses the library, but you have their caregiver, their guardian, you know, their parent or someone else who wants materials to help you, you know, return materials checked out maybe by this disabled individual. Well, the library cannot give that information to even a guardian or a parent without a specific waiver. So again, keep that in mind if you've got patrons with disabilities, that you have to be very careful with respect to information that you give out even to their guardian. We also have been starting to address what, you know, disabled or vulnerable adults in policies about, you know, that are very similar to what you would consider an unattended child policy. Because of the nature of the library, there's a lot of people with disabilities that use the library during the day. And what happens if they are unable to, you know, come and go from the library without assistance from a guardian or parent? What happens if they're still in the library at the time of closing? So these are other issues where you might have to start looking at your policies with respect to disabled individuals to make sure that there's a safe, they can safely use the library and use the library in the same manner as any other patron. Well, we covered a lot of topics, and I really appreciate all your patience. If you have any questions about any of the topics we covered, my contact information is on the front page of the PowerPoint. You'll be getting a copy of this PowerPoint after the presentation. So I'm happy to hear from you if there's anything that was unclear, if there's any more information I can give. Thank you very much.